Hello. So we're going to go ahead and get started on our next presentation. Hope you all had a good lunch. When I went into work this morning, it was a nasty, rainy, cold day in Kansas City, the Kansas City area, and now I'm here in Overland Park, and the sun is coming up, so things are maybe looking up. But I'm here to talk to you. My name's Alex Schulte, if we haven't got a chance to meet, and I'm here to talk to you about the Stark Law and Anti-Kickback Statute regulatory changes that were released last November, and most of which went into effect in January 19, with the exception of a few changes to the Stark Law that are going into effect January 1 of next year. And we'll note those as we go through the presentation. I remember distinctly when the proposed rule for these regulatory changes to the Stark Law and Anti-Kickback Statute was released was in 2019. We got together in a conference room, kind of poured over the changes that were proposed and the effect they might have. And I think our idea at the time was that this was going to be kind of the big healthcare news, or at least healthcare regulatory news of 2020 when the final rule did get released, because it's been a long time since Stark Law had been updated in this way, and there was some potentially pretty significant things that were in it. But of course, what ended up happening is the world came to an end in March, and COVID and all the federal statutory and regulatory changes and the programs kind of pushed these changes to the off the front page, but they were still, the final rule was still issued at the end of 2020 and has largely gone into effect, and it is significant. So in this presentation, I'm going to give kind of a primer on the Stark Law for those of you that are less familiar with it. Go through some of the changes that were instituted through the final rule. The big headline that you may have heard about was the kind of embrace of value-based models, some new exceptions for what they call value-based enterprises, and we can talk about what that entails. But there's some other stuff in there that maybe isn't getting quite as many headlines in the healthcare world that could have just as big an impact in the short term, at least, or even bigger impact on you and your operations. And that's the refinement or definition of the concept of vary with value or volume of referrals, and then commercially reasonable and fair market value. These concepts that are sort of built into a bunch of different exceptions in the Stark Law and are really important components of Stark Law compliance. Also some changes to the group practice rules that are sort of buried in the final rule that I think group practices certainly need to be aware of. And some other new exceptions that some of which I think could be pretty useful to you if you have a potential Stark non-compliance issue. Also, I'll talk more briefly about the Anti-Kickback Statute and the changes that were in that final rule as well, which was issued roughly the same time, and also went into effect January 19. There's some value-based enterprises information or safe harbors that are part of that. There's also some new safe harbors and some kind of tweaks to some existing safe harbors that I want to briefly mention. So what is the Stark Law? The Stark Law is a federal statute that prohibits a physician who has it prohibits an entity from billing Medicare or Medicaid for services that are referred to that entity by a physician that has a financial interest with that entity. So there's a number of questions we ask ourselves when we're kind of contemplating whether the Stark Law prohibits a certain kind of transaction or relationship between a physician and an entity. Obviously, the first you need a physician involved. The Stark Law doesn't apply specifically to non-physician providers or referrals from other sources other than physicians. If you have a physician involved, the next question is the physician making a referral of designated health services? The Stark Law defines designated health services pretty broadly, and so you have to ask the question of whether the referral that the physician, or the service that the physician is referring does qualify as a designated health services. And like I said, there's a lot, a wide variety of services that do fit within the category of designated health services, and a lot of the kind of things that we're concerned about usually do fit within that category. And so then the question is, does an exception, if the answer to all of that is yes, the question is, does an exception apply? And what makes the Stark Law scary and compliance with it so important, comprehensive compliance with it so important, is that it's a strict liability law, which means that intent doesn't matter for the purposes of determining whether the law was violated. You can think of it like a speeding restriction. It doesn't matter if your speedometer was broken. It doesn't matter if you thought you were going the speed limit. If you're going over the limit, you're guilty of violating the law. And so we can even have technical violations of the Stark Law that are completely innocent, that can have big repercussions. And part of the reason that repercussions are so big is because every time you file a claim that's in violation of the Stark Law, a claim to Medicare or Medicaid that is part of a relationship that's prohibited under the Stark Law, or the financial relationship exists and the referral is prohibited under the Stark Law, well, then you have a false claim, and you're subject to penalties under the False Claims Act, including whistleblower lawsuits, and that could come along with it, treble damages and all kinds of different penalties. So Stark Law compliance is a big deal, and even if you aren't personally familiar with the Stark Law, a lot of kind of concepts that you see in contracts that you sign, things that, arrangements that you have with physicians are really predicated on trying to make sure that your arrangements fully comply with the Stark Law, even if you're not aware that that's why those are in the contracts. So the final rule, they titled it Modernizing and Clarifying the Stark Self-Referral Regulations. Again, it's going into effect, or most of it went into effect January 19, 2021, except for some group practice rule changes, which aren't going into effect until the beginning of next year. And we'll talk about why those were delayed in a subsequent slide. But according to CMS, I guess CMS has described the purpose of these changes as twofold. One is they wanted to accelerate the move toward value-based care, pay for performance kind of models, and away from traditional fee-for-service, which is something CMS has been emphasizing for a long time, the regulatory sprint towards value-based payment models, value-based care. But they also, as I pointed out in this quote, I copy-pasted, they thought that their changes would alleviate some unnecessary regulatory burdens. I think that's true. In some aspects of the changes are going to be helpful in alleviating burdens. Other aspects maybe are going to create new regulatory burdens. But we'll get into some of the reasons that some of the changes might be helpful to you in complying with the Stark Law moving forward. So value-based enterprises. So again, the idea, the Stark Law has been an impediment to development of value-based payment models. In some ways, the Stark Law is kind of predicated on fee-for-service. It's sort of value-based. The reason that we care so much about the reason the STARK law exists is we don't want physicians making referrals for the wrong reasons. So they make a referral, that service is performed, they get a fee. They don't want referrals to be made on that basis. But if we move to a true value-based model where providers are being compensated based on the quality of the care, the value that they provide, then we're much less concerned about why referrals are being made. What ultimately matters is the patient was receiving a good quality of care. But CMS recognized that in some ways analyzing, there was a mismatch between the way the STARK law is set up and the ways these value-based payment models might be set up. And so they thought that there was an opportunity to provide some new exceptions that might be helpful, and the exceptions to try to facilitate that transition to value-based and away from fee-for-service. The exceptions are for value-based enterprise, and that's broadly defined as 2 or more suppliers or providers that collaborate to achieve value-based purpose, which we'll talk about in a second. But I just want to emphasize these value-based arrangements, at least for the purposes of the STARK law, are not, kind of informal understandings. They're written, they need to have a formal kind of documentation, a written document describing what the purpose of the entity is or the enterprise is, and how they're going to go about achieving the purpose. It doesn't have to be a standalone legal entity, but it needs to be, needs to have formal kind of documentation and a mission, a purpose and ways of achieving it. Also needs to have a body or person that's responsible for oversight, including oversight over the finances and operations. Excuse me. So what is a value-based purpose? Well, broadly, coordinating, managing the care of a target population, improving quality of care, decreasing cost, or at least limiting increase in costs, and then generally kind of transitioning away from fee-for-service and into quality of care, and comp based on quality of care and control of cost. So what are these exceptions? I'm going to talk about these as a really high level because time is limited, and to this point, I haven't seen in my practice a lot of people trying to set up these kinds of value-based enterprises. And in the long term, maybe we'll see more of it. But to this point, I don't know that I've seen it. And so I want to make plenty of time to talk about the other changes that are maybe going to have a more immediate impact on your day-to-day. But it is interesting the way these are structured. Basically, we have 3 different exceptions under the STARK law. And again, when we talk about STARK law exceptions, if the STARK law applies, an exception is necessary. Compliance with all components of the STARK law exception is essential. So you need to make sure you're ticking off all the boxes for an exception. And here's the 3 exceptions that they created at a really high level. One is where the participants have full financial risk for services, items and services for a healthcare, for a target population. So the provider's comp is payments is at risk, fully at risk, depending on the care they provide. There's substantial downside risk for physicians. And, if the physician's comp is subject to significant decreases based on value-based purposes, as I mentioned in the previous slide. And then the third exception doesn't actually require a specific level of risk from physicians or other providers involved, but it does require that there's value-based objectives and that they're closely monitored, and that there's the other kind of technical requirements of the exception are complied with. And the way they've structured this, which I think makes some sense, is that the higher level of risk the parties involved bear, the fewer requirements there are to comply with the exception. So if you have on one end of the spectrum, you have a full financial risk model, then complying with the exception is relatively is relatively easier. There's fewer like technical requirements. But then on the other end of the spectrum, if you're doing the no risk required option, then it could be pretty burdensome, and I think would be pretty burdensome to comply with the exception. So where does this all go? How impactful will this be? Did CMS really achieve their objective of promoting value-based models? Sort of remains to be seen. I kind of think that more Stark law reforms are going to be necessary to truly facilitate a large shift to value-based models, but we'll see. And I do want to point out, and I'll talk about this when we get to the anti-kickback stuff, but the Stark law, which is administered by CMS, and the Anti-Kickback Statute, which is administered by the OIG, they both incorporated value-based exceptions in their final rule from January 19, effective January 19, but they're not exactly the same, which is often the case when it comes to comparable or similar Stark exceptions and anti-kickback statute safe harbors. They're not the same. They don't have to be the same. And so you do have to go through the process of analyzing both. Here, like with all exceptions and safe harbors. But if you have other questions about value-based enterprises and what these exceptions might look like, I mean, feel free to drop them in the comments, and we can talk about them and stump the panel. But certainly would be happy to talk at more length about how these actually work with anyone who's interested. But here's where I think this might be one of the most interesting parts of the final rule. There's this concept of varying with value or volume of referrals that's kind of sprinkled throughout the Stark law in the exceptions. You can't have a physician services arrangement, for instance, where the comp varies with the value or volume of referrals. You can't have a lease agreement where rental payments vary with the volume or value of referrals. It's an important concept. It's never been clearly defined by CMS, and I think it was helpful that they wanted to. I think they were right to want to provide more clarity here. And here's what the standard that they ultimately came up with, and that was part of the final rule. And the standard is: does the formula for compensation include referrals and other business generated as a variable, with comp correlating with the number or value of the physician referrals? So if referrals go up, does comp go up? Or vice versa, if referrals go down, does comp go down? This is kind of a conceptual departure from the way it's framed previously. But they provided some exceptions. I think I still have some questions about how this is going to be enforced. They provided some examples in the guidance that was issued along with the final rule. The examples they provided are certainly things that I would have thought were violations of the this vary with volume or value of referral standards before this guidance was issued. I guess I should emphasize, when they say formula for compensation, they don't necessarily mean the formula that's set forth in the services agreement or whatever other kind of compensation arrangement that you've entered into, payment arrangement you've entered into with the physician. They mean, can you come up with a formula where there's this correlation? And so one example they gave, I forget exactly the entity type, but a physician signs a services agreement with an entity, and under that services agreement, his payment, his consideration for the services he's performing is a percentage of the overall profits generated from the entity as a whole. And CMS kind of breaks that down and says, okay, well, that definitely varies with the volume or value of referrals, because we can come up with a formula where he gets 2%. This physician gets 2% of all referrals from other from other physicians, 2% of all referrals of non-designated health services, but he also gets 2% of referrals from designated health services that are referred by this physician. So there's clearly a correlation. We can describe that as in a formula. I think it remains to be seen how kind of impactful this is going to be. I think it has been sort of helpful to me and to some of our clients in thinking through arrangements and whether there's a potential variable issue in a compensation arrangement. But again, we'll see how CMS and courts interpret this moving forward. This is kind of in a similar vein, commercial reasonableness and fair market value, really important concepts across the Stark law. You see a bunch of exceptions that are incorporate these two kind of concepts. Commercial reasonableness is different from fair market value in that fair market value relates to whether the compensation paid, the amount that was paid was fair, and we'll talk about what the way that definition has been refined. Commercial reasonableness relates to the arrangement as a whole, not just compensation, but is the whole thing reasonable, commercially reasonable. And in order to be commercially reasonable, it has to further a legitimate business purpose of the parties and be sensible, which is kind of a slight redefinition of the term, probably not too impactful. They do say that they're going to consider the characteristics of the parties, including the size, type, scope, and specialty. So there isn't like an objective standard for commercial reasonableness. It's facts and circumstances dependent. What kind of provider are you? What are your circumstances? What are you up against? And then I think the key takeaway from the changes that they made to the commercial reasonableness standard is that profitability is not required for an arrangement to be commercially reasonable. There was some doubt about that, certainly. This is helpful that CMS has said this. We certainly have, hospitals in Kansas, for instance, that have unprofitable arrangements with physicians. Specialists, they want to keep service lines open. They're not making money necessarily. In a lot of cases, they're not making money. And so it's nice to have this kind of codified in the regulations that profitability, commercially reasonable does not mean must be profitable. So fair market value, I think they also kind of refine the definition of fair market value in a way that maybe is a little bit less impactful. Arm's length transaction, they talk about general market value being the price between well-informed parties who aren't referring business or generating business to one another. And then specifically when it comes to office space and equipment leases, they're considering value for general commercial purposes. You can't take into account intended use. So I mean, generally, when you think about fair market value, it's arm's length. Two well-informed parties that aren't affiliated with each other, that aren't, are creating business for one another, not referring cases. What would they pay for the service or for the lease, the rent? And so I don't know that this is a big conceptual departure from prior guidance, but maybe some more specific examples are provided and some additional kind of helpful guidance there. So group practice rules, this is not a headline, I think, but if you dug into the final rules, you saw this, and it is pretty noteworthy for the group practices out there. So as you know, in order to, if you are a group practice, it's really important that you comply with the group practice requirements under the Stark Law, the requirements to fit within the definition of a group practice. That in order to take advantage of the in-office ancillary services exception, a physician group needs to qualify as a group practice. So group practices are subject to restrictions on how they distribute overall profits from designated health services. Again, those are those services, the broad range of services that are subject to the Stark Law. So Medicare, Medicaid, designated health services have to be distributed in a particular way. What the final rule said is that it's not okay. One of the things the final rule said, it is not okay for a group practice to distribute profits from DHS based on the kind of service that's provided. So the example that is used in the regulations is if we have a group that's, has, let's say 3 physicians who get all the revenue from imaging, and then 3 different physicians who get all the revenue from lab, that is not a permissible distribution of overall profits. What you have to do is aggregate those overall profits from all different kinds of DHS. Again, the designated health services that are payable by Medicare and Medicaid. You got to aggregate all those profits, and then distribute it based on a formula that doesn't take into account referrals. Directly take into account referrals. So there are, a number of physician groups, a lot of physician groups that were doing something like this. They had some physicians who were more involved in a certain kind of service line that might produce certain kinds of ancillary services. They said, okay, well, you get those profits because that's really your kind of area, and we'll take these profits because this is our kind of, our area. And what CMS kind of concluded is that's not overall profits from DHS, and overall profits is the key term. And they're saying overall profits means all DHS profits pooled together and then distributed based on with one formula to the various physicians. This doesn't mean, I should note, that you can't have a subgroup or a component of a group that can consist of at least 5 physicians, where you can kind of segregate those 5 physicians off and distribute profits to those 5 physicians based on a predetermined formula. But even within the subgroup, even within the component, the designated health services have to be aggregated from all different kinds of designated health services. We can't, even within a subgroup, we can't say, well, you get this this profits from DHS for imaging, and you get this from lab. It needs to be aggregated and then distributed. And CMS recognized that this is not necessarily what a lot of practice groups had understood, and that's why they made them not effective until January 1 of 2022. So these still haven't gone into effect. Happy to answer any questions. We've been helping a lot of physicians kind of work through this change, and our physician groups work through this change and ways to kind of ensure compliance without reinventing the wheel, and happy to discuss with anyone. And then they also added a rule about participating in value-based enterprises, group participation in value-based enterprises. So temporary non-compliance with writing signature requirements. These are the kind of other exceptions that I wanted to point out. This is a good one. It is limited, but it's a good one, and it can be helpful. If you have temporary non-compliance because you don't have a writing and a signature, so there's some requirements like the personal services exception that you would use if you had a PSA with a physician that explicitly require that you have a writing and a signature. If you enter into an arrangement with the physician and you meet all the requirements of the exception, except for you don't have a writing and a signature, you can get that signature and the writing within 90 days after the arrangement starts. So the classic example is you're a hospital, you want to hire a physician to be a contractor, provide services on a contractor basis. You have the agreement, it's set in advance, it's commercially reasonable, it's fair market value, it meets all the other requirements for the personal services exception, but you don't have a writing. You just don't memorialize it in writing. Or, you could do the same thing with like a lease or whatever. You realize it, 30 days later, you get a writing and you can still be in compliance. What you can't do is start an arrangement, not have the details figured out, just have him start working, not knowing what he's going to be paid or whatever. And then 90 days later, decide, okay, here's what we're going to pay you. Let's get something signed and then backdate it to 90 days before. That doesn't work. It has to be all the requirements of the exception were met, except that you didn't actually go through the process of getting it right, but it can still be helpful. There is another exception for limited physician remuneration agreements. So you have some kind of agreement with a physician that you don't put into writing, but it's commercially reasonable, fair market value, doesn't vary with referrals, and it's less than $5,000 a year. That can comply with the Stark Law even if it's not in writing. And so that can sometimes be helpful too. Also, they added an exception for donation of cybersecurity technology if they want to kind of promote sharing of cybersecurity technology among different entities. So here we're going to do an introduction to the Anti-Kickback Statute. There is a poll here that you're going to see in mine now. So please respond to the poll, or you can type the code into the chat like you've done in other presentations. I'll go through the slide here and then remind you at the end that you need to click on this. So the Stark Law and the Anti-Kickback Statute are all paired together kind of analytically, but they have some important differences. The Anti-Kickback Statute's what it sounds like. It prohibits kickbacks or payments in exchange for referrals. Key differences, though, it's not limited to Medicare or Medicaid like the Stark Law is, and it's not limited to a defined category of health services, designated health services like the Stark Law is. This is any service payable by any government payer is subject to the Anti-Kickback Statute. It's also not limited to physicians. So the Stark Law only directly applies to physician referrals, whereas the Anti-Kickback Statute applies to referrals from non-physician providers and from non-healthcare providers, from marketing people and stuff. That's all subject to the Anti-Kickback Statute. It also is not a strict liability statute. It is a statute that requires intent. It doesn't necessarily mean that you intended specifically to violate the Stark Law or the Anti-Kickback Statute, but it does mean that you intended to solicit, offer, pay, receive remuneration, anything of value in exchange for a referral. And then the safe harbors are different than the Stark Law exceptions because the compliance with the safe harbor is not mandatory in order to avoid violation of the Anti-Kickback Statute like they are with the Stark Law. I mean, if the Stark Law applies and you need to comply with an exception and you don't, you're in violation. But if the Anti-Kickback Statute, if you don't comply with a safe harbor, you don't quite fit within a safe harbor, then there's still this analytical question of whether you're in violation of the Anti-Kickback Statute. So safe harbor compliance is a good idea, and we always recommend it where possible, but it's not mandatory like it is in the Stark Law. So again, make sure you click the poll or type the code into the chat. I'll give you one more minute here. I should note that the final rule here was also went into effect January 19. I think in its entirety. There wasn't any components that had a later effective date. So what's a value-based? How does the anti-kickback statute exceptions describe value-based arrangements? Well, they're conceptually, like I mentioned in the previous slide, they're conceptually pretty similar to the Stark exceptions, but they're not exactly the same. There's the new safe harbors. And again, when we're talking about safe harbors, we're not, it's different than a Stark law exception in that compliance isn't absolutely mandatory and we don't have to go through, did we check every single box? But generally, they bear a close resemblance to the Stark law exceptions in that there's a full financial risk safe harbor, there's a substantial downside financial risk safe harbor, and then there's a third kind of safe harbor that isn't contingent on risk. And the way they describe it is care coordination arrangements to improve quality health outcomes and efficiency. So if you're ever to pursue a value-based arrangement that fits within that third category, the low risk or no risk, excuse me, model or not risk dependent model for the Stark exception or the safe harbor, you would need to real carefully go through that exception to the Stark law and through the value-based safe harbor here under the Anti-Kickback Statute to make sure you're completely complying with both. There's a carve out in the final rule. They instituted a carve out from the definition of remuneration. So when we talk about remuneration under the Anti-Kickback Statute, which is what you're prohibited from paying or receiving, soliciting in exchange for referrals, is the term is remuneration, which is pretty broadly defined, anything of value. But they carved out from remuneration outcome-based payments, which I thought was kind of interesting. And this is measured by, this is kind of separate from the safe harbors, but it's measured by clinical evidence, benchmarks for quality of care, reduction in cost, but it also must be commercially reasonable, fair market value, and not take into account referrals. So maybe some questions about how big of an impact that's going to have. But anyway, that was incorporated into the safe harbors. Again, I think just like the Stark law, that we will see what ends up coming out of this. It may be that this is in the long term, these kinds of safe harbors and value-based care concepts that were incorporated into the Anti-Kickback Statute through this final rule are going to be extremely significant. My guess is a lot of you haven't been involved in these kind of value-based arrangements since this was instituted earlier this year. But it'll be interesting to see and track kind of the progress of value-based models in the next few years in particular. There's a couple other real notable things that I wanted to point out in the Stark or in the Anti-Kickback Statute changes. One, if you have a value-based enterprise and you have patients that are within the value-based enterprise, you have a new flexibility under this safe harbor to offer tools and support as necessary for the patients to pursue the kind of value-based purposes. And I think value-based purposes or objectives are pretty similarly defined in the Stark law guidance and in the Anti-Kickback Statute guidance. So it's things like controlling costs, improving quality of care, facilitating a move away from fee-for-service into value-based models. And so that there's a safe harbor for that, and it can't exceed $500 per year. There's also there's been some CMS-sponsored innovative payments models, as you know, and there's never been a safe harbor recognizing that services arrangements that comply with the requirements of a innovative payment safe harbor comply with this Anti-Kickback Statute. Now we have one of those. We also have a cybersecurity technology safe harbor. So there was a cybersecurity exception that was incorporated in the Stark Law in a cybersecurity safe harbor to the anti-kickback statute. Also, I wanted to note, rural providers, you might have a discounted transportation program, a free or reduced cost busing program or something similar. If you do, you know that there's complying with the local transportation safe harbor is really important, and there's some technical restrictions on mileage and that kind of thing. And one thing they did in this is that they expanded the mileage restriction from 50 to 75 miles for providers that are located in a rural area, which I think could potentially, and I know will be helpful to some providers in rural parts of Kansas. They also removed mileage limitations for transportation of patients to their residence after an inpatient admission or 24-hour observation. So while you're generally subject to a mileage limitation for other kinds of services, if you're bringing somebody back home after an inpatient admission or 24-hour observation, you're not subject to those same restrictions. I think the bottom line on a lot of this stuff is when we're approaching physician compensation arrangements, we need to keep in mind the standards that are kind of incorporated throughout the Stark Law. Is it commercially reasonable? Is it fair market value? Does it vary with the volume or value of referrals? I mean, every exception is different, but those are in a whole host of exceptions. And I think the big takeaway from this for everyone is we need to think about varying with volume or value of referrals in terms of, is there a formula that we can come up with where as referrals go up or business generated goes up, comp also goes up. If it is, then if there is, even if it's not the formula that's explicitly used in the contract, then we have a potential problem. Commercial reasonableness, I think this is, and while I don't know that that's necessarily good or bad, it is kind of helpful to have that vary with volume of referral standard set forth in the guidance, and we'll see what additional kind of guidance comes out of that in the future. In terms of commercial reasonableness, the big takeaway is it doesn't have to be profitable, which I think provides us some comfort in some of our physician arrangements. And then group practices, like I said, this is kind of the changes that were made in distributing overall profits might be different than what you're currently doing, or you at least want to review your physician employment agreements or profit sharing agreements or whatever to ensure that what you're doing really does completely comply with the new guidance, because as CMS has recognized, this wasn't everyone's understanding of what the rule for distribution of overall profits are. So I think that's kind of the bottom line from my perspective.